Have you been anxiously waiting for the brief to be filed by Department of Homeland Security? Well, I've been writing it throughout the past weekend. And by the way, thanks for a new person for sharing this document. We want to watch the rest of this video. My name is John Ting. We help you secure your legal status to live and work in America legally. Let's get to it. Okay, so DHS went straight to the heart and tried to go for the TKO, okay? And they told the 16 states, hey, there's no point even going through whether it's valid or invalid program because they don't have standing. You might ask, well, what does that mean? So any person, any party who files a lawsuit, they're called the plaintiff. So the plaintiff has to prove by preponderance of the evidence, I'll explain that in a second, that they have suffered or will imminently suffer some kind of damage. In courts, in law, they call it injury. But the injury cannot just be guessing. We call it non-speculative, okay? So they can't be just making shit up. The law uses the word concrete when it relates to injury, meaning, again, you can't just make it up. And even if there is a concrete and non-speculative injury, that injury is traced, is directly related to the actions or that program, for example, PIP program. So, can the plaintiffs do that, the 16 conservative states? And to take it a step further, if there is that direct connection and causation, okay, will there be a difference if the PIP program goes away, if it's just invalidated? Will that injury no longer be there? Let me know what you think in the comments. The first problem with the plaintiff's argument is that they believe that the PIP program will somehow increase the number of non-residents into their states. They already live here. This program is not for people who are recent entrants. The program specifically has a requirement that they have to have lived here for at least 10 years. I don't know why, but I get the feeling that the conservative states just have not learned from the past. That every time they think there's some kind of new immigration program that's just going to create this floodgate. No, DACA did not create that in 2012. Okay, so you might wonder, well, so what? If there's more people living here, what else are they saying? Okay, so the 16 states have said that, okay, with more undocumented folks who can claim to file for this PIP program, that it's going to increase the cost for three main things: education, healthcare, and law enforcement. We already know these costs are already increasing regardless of the number of people. Are the states trying to say that they're footing the bill for this, or is it really the taxpayers like you and me? All right, the states are supposed to be for the people, right? Okay, so earlier I mentioned about preponderance of the evidence standard. That is very important. That's like law school 101. So preponderance of the evidence standard means that there's enough evidence to make the claim, their cause of action, more likely than not to be true. But is that really the case? In the next video, I'll explain and go through some of the pieces of discovery. So follow for more.